Thanks very much, and thanks for having me. It's nice to be introduced coming from the leading public law set in London. There are three major public law sets in London, and I don't know if you know Keelan Gallagher. She is at one called Doughty Street, and she would be horrified to hear that my chamber is described in that way, since she sees us as a den of iniquity. It's true that I have appeared in many of the cases, and some of the cases I'm going to describe today. I have to confess right now, before Irish public lawyers, that in nearly all of them I appeared for the forces of darkness. But the cab rank rule, and everyone deserves representation. The tricky one for me in this discussion is, unlike, I suppose, the situation here, there's been a mountain of case law in the UK on the Human Rights Act. And so I have to find topics that are of potential interest to you. And I also have to exclude the ones that mercifully are unlikely to arise in this jurisdiction. So all the cases about torture, extraordinary rendition, mistreatment of Iraqi civilians, you should be grateful that those cases, though interesting, don't come to the Irish courts. But there are some cases in English courts that do create at least the potential for interest and possible influence in the Irish jurisprudence. And I'm focusing today on the following topics. First of all, under Article 6 of the Convention, I'm assuming here a general knowledge of what the articles say. Under Article 6, the definition of a civil right and obligation, especially in the social welfare context. Under Article 8, the right to housing and the characterisation of Article 8 rights in that sphere. And finally, touching on the continuing tension between privacy rights under Article 8 and free speech rights under Article 10. We're going straight to Article 6 and this vexed question, which must arise in this jurisdiction as well, about the proper characterisation of social welfare benefits as giving rise to civil rights and obligations. Because as you all know, the early jurisprudence of the European Court of Human Rights was that there was a clear distinction between civil rights and obligations, which were seen as private contractual or tortious rights, which were distinct from public law rights, things that were within the gift of the state. But as the case law in Strasbourg has evolved, they have taken a more expansive approach, and now, on one view, a very expansive approach, most forms of social benefits can be seen as giving rise to civil rights and obligations under Article 6. And you all know the importance of that, because it gives rise to the important procedural protections guaranteed by that provision of the Convention. This came to a head in a very recent English case, a British case, called Tomlinson, 2010 in the Supreme Court. And you will all smile wryly. I said in my paper that when I refer to the Supreme Court, I refer to the brand new English copy, British copy of the more venerable Irish institution. And not simply in the name of the court, but in the approach of the court, have the UK judges moved closer to an approach which is very familiar to you. And part of the reason why I imagine the case law in the Irish courts has been more disappointing is because it's less necessary in some ways. I mean, I appreciate that we have our own differences about that. The Human Rights Act was a revolutionary measure in British law, and although the judges constantly repeat the importance of the supremacy of Parliament, the reality is that there has been a recalibration in the British Constitution, which hasn't happened here for the reason that it wasn't necessary. So, coming back to Tomlinson, as a case that relates to the 1996 Housing Act, which is closely paralleled in the Irish statute, and there's a provision that deals with homelessness. I won't go into the statutory material in detail, but just in summary, there's a duty on local authorities to provide accommodation in the general sense. If they assess whether a homeless person is eligible, and they provide accommodation. If that accommodation is refused, the local authority can declare that it's satisfied itself, that it's complied with its statutory obligation, and the person has a right to challenge that decision to a housing officer, and a further right of appeal to the county court, but only on a point of law. No factual dispute can be raised. In this case, Tomlinson, various appellants raised this point, but in one case, Mrs. Ali said that she'd seen the flat, she had been dissatisfied, so she had refused. The council said that they'd written to her. She said she never got the letter, and that was the factual issue in dispute. And because it was a factual issue, of course, the county court couldn't look at it, and that was the end of her day in court. And she, with the others, alleged that this violated Article 6, a civil right and obligation arose, and she had various procedural protections. Now, those of you who are familiar with the English jurisprudence in this know about a case called Runa Begum, where this very question arose. And Lord Hoffman, in one of his more illiberal moments, was obviously desperate to say that Article 6 wasn't engaged. But at that stage, he hadn't decided to take the war to Strasbourg in the way that he has done since, particularly since he retired. And so he did duck the question. But the current Supreme Court didn't duck the question. They looked at the European case law and they distinguished it. Salesi was the principal case they looked at. That was like a high water mark, which found that social payments, even purely out of public funds, still gave rise to civil rights and obligations. Those were distinguished on the basis that, unlike in Tomlinson's case, they weren't payments in kind. And Lord Hope pointed out that the kind of social benefits that were an issue in Tomlinson were not individual rights. They involved a series of evaluative judgments, and they lacked precision. For these reasons, he said, they couldn't properly be characterised as giving rise to civil rights and obligations. They fell outside that category, and therefore outside Article 6 entirely. And on one view, this wasn't an unjust decision, because as Lady Hale, who's normally an important liberal voice in the court, said, it's important in the general interest that these procedures don't become over-judicialised, because it inevitably means a diversion of resources in these local authorities away from the business of providing accommodation to needy people and into lawyers' pockets. So a balance has been struck, for better or for worse, and that is the balance that's been struck in the UK. This has significance in the sense that when you come to my next topic, you can see why in some ways, when you look at Article 8 rights, you can see sometimes a difference of approach between the expansive approach to Article 8 and the more restrictive approach to Article 6, and perhaps that's something we can discuss later. Returning to Article 8 and the recent case law, because there have been important new cases in England on housing rights, which have, I think, direct significance for ongoing litigation in Ireland. The case that I'm going to discuss is Pannick, a very recent case of the UK Supreme Court. And in that case, the court had to consider the proportionality of whether Article 8 required the court to consider the proportionality of evicting someone from their home. And in that case in particular, the proportionality of a local authority evicting someone from their home. The statutory background again arose from the Housing Act. Normally local authorities have secure tenants, but in a fit of illiberal peak, the British government introduced in 2003 the Anti-Social Behaviour Act, the ASBO Act, which allowed local authorities to demote people with secure tenancies. So you have a secure tenancy, but if your children get rowdy and out of hand, the local authority can serve you with a demotion order. And from that moment, within a fixed time period, the local authority has the right to serve a possession notice on you. And again, you had no right to appeal that to an independent and impartial tribunal, and no right to challenge at any point of fact the lawfulness of the possession order. You were effectively on a notice period, and once you were on that period, the local authority would have the threat of eviction hanging over you. Mr. Pannick had lived in the house for 30 years. He had 5 very, very rowdy kids, and he was served one of these orders, and he was served a possession order, and he took his case saying that the proportionality of the eviction notice was crucial and guaranteed by Article 8.